Good. All right, we are live. All right, good afternoon, everyone. Shortly after 2:30 PM on April 15th, we are picking up work on S 298, an act relating to creating the Vermont Voting Rights Act. We are taking continued testimony this afternoon on a couple of different pieces, and we are going to start off on Zoom with our old friend Ben Williams. Ben, how are you?
I'm doing well, Chair Byron. How are you?
Just fine, sir. Thank you for asking. So, yeah, no, we want to welcome you back. I know you had some feedback and thoughts about this particular piece of legislation. So just wanted to open the table up to you and your thoughts.
Well, I appreciate it. Thank you. And thank you, Vice Chair Hango, Ranking Member Waters Evans, members of the committee, for having me. For the record, my name is Ben Williams. I'm Senior Policy Counsel at Fair Vote Action. We are a 501c4 nonprofit that advocates for better elections around the country. The various policies that can fall into that are quite varied, but one of them is state voting rights acts and the various provisions therein. So really appreciate the time to talk to you today. This bill has changed a lot since it was first introduced in the Senate. You all know that as well as anyone. I reviewed some of the previous hearings that you've had in this committee on the bill thus far. So if it's okay, I'd like to keep my remarks tailored to just answering a few specific interest points and questions that I've heard in prior hearings, and then leave the rest of my time for any questions that you might have. Hopefully that is just a quicker way to get through this. So the first point is one of the reasons why the bill was tailored so much in the Senate down to this level was the policy in Vermont that election bills are not passed in election years, and trying to keep what was included in S 298 to just mirror what is in federal law, so that you're not actively changing any of the burdens on Vermont's clerks, and you're not changing any of the burdens on any of the other agencies in the state. So when you see the versions that go from 1.0, that was this many pages, to 1.1, which was almost 50, down to the version before you today, that was the logic, was getting all of the ideas on the table and then cutting it down to the core components that were important to pass this year. There are other topics that I know were discussed in committee, and I know that you might have someone from Senate GovOps come over, but just to give you an idea, like disability access was something that I heard come up in a previous hearing. That's obviously something that we would be supportive of and we think is very important. And my understanding is that based on what Deputy Secretary Hibbert testified a couple of weeks ago in this hearing, it sounds like there's going to be a process over the summer where some of those issues might be ironed out, and the policy that's adopted is tailored to Vermont's specific circumstances. I would support any inclusion of disability rights as being a result of that deliberative process over the summer and potentially being included in 2027. I think that's a great idea. Next, there was a question about the protections section. I think this is 2901 7A. It's at the bottom of page 7. This is about the campaign finance funds for personal security. This is not something that Fair Vote has researched extensively, so I don't have a recommendation for you on exactly what language should be included here, but I will say that we are broadly supportive of the idea that in an era of enhanced security threats and security risks to candidates and elected officials, we support states adding in flexibility into their constitutions or their statutes to allow for candidates to do appropriate steps to take care of their own personal safety. What exactly that is, whether or not you include things like firearms or weapons or not, I defer to your judgment and best wisdom, but the broad principle, I think we are supportive. Your safety and the safety of other candidates is a top priority in this time. Third, there was a discussion about a private right of action for vote dilution specifically. I know that there's a couple different sections that have vote dilution in this bill and others that don't. There was vote dilution, private right of action on the Senate side, and it ultimately got pulled out. I think that was a drafting error. A private right of action for vote dilution already exists in federal law. So if you added that into this bill, that would not change anything meaningful for the rights of Vermonters. If you added something simple back in, there's previous language that you can find in old drafts that might be appropriate. But if you were to do that, just know that is not something that's going to fundamentally alter any of the rights that Vermonters have or alter the burdens on clerks, because they've been subject to that since 1965. The fourth, the vote dilution standard. I know this is something that the AG's office testified a lot about in the previous two hearings. I will just say, under the principle of keeping things tailored to not changing policy in an election year, we would be supportive of leaving the language as is and keeping it closely hewn to federal law. And then if there was some discussion about whether or not to expand that to be more specific or be broader or tailor it to Vermont circumstances in the future, we would certainly be open to that conversation. But for the moment, I think leaving it as is perfectly appropriate. It mirrors the protections that have existed since the Voting Rights Act was passed more than half a century ago. And then lastly, Deputy Secretary Hibbert testified about changing the name of the bill to the Voter Protection Act. Fair Vote Action is supportive of that change. This bill has some really good provisions in it that I think are really important for Vermont to pass this year. And I'll say more about that in a moment. But a Voting Rights Act typically has more sections than vote dilution and some protections for clerks and for voters against threats of intimidation or violence. And so the changing the name to the Voter Protection Act, we think is appropriate and would fit the circumstances here. But lastly, I want to end with why we're talking about this in 2026 and why we're doing this, why we're supportive of this bill in the first place. And it's because you have a policy of not changing election rules in an election year, and we're actually at risk of the United States Supreme Court doing exactly that. For the past 60 years, Vermonters have enjoyed the rights in the Federal Voting Rights Act. And those rights are currently under threat in the Calais case pending before the United States Supreme Court. If those rights were to go away, you would have a change in election law in an election year. By passing S-298 and incorporating the federal provisions into your own state code, you would have those protections for this year, regardless of what the Supreme Court does later this spring or this summer. And then you could always come back next year and add on additional provisions that might go above and beyond and whatever this legislature thinks is its best judgment for what kind of protections a state voting rights act in Vermont could or could not include. But for 2026, this is really tailored to these very specific circumstances. It's meant to be continuous and it's meant to avoid changes and disruptions in your existing structures. And that's why I would encourage you to pass S-298 with maybe some minor changes. But with that, I'm open to any questions and thank you for the time.
Oh, of course. Any questions for Ben? Yes, Rep. Hoover.
I'm curious to learn more about that Supreme Court case, its implications. How soon do we learn more about that?
Sure, Representative Chairman. Yeah,
Yes.
Absolutely.
Please.
Happy to help. So the case is out of Louisiana. It's called Calais, and it's about a Voting Rights Act lawsuit that was brought, I believe, in 2021 or 2022. I don't have the exact date in front of me. Challenging Louisiana's redistricting system as unduly diluting the votes of Black voters in the state. The plaintiffs prevail. They drew, the state drew a new district to allow the African-American community an opportunity to elect their candidate of choice, which is standard practice and has been the case for the Voting Rights Act for well over 30 years at this point. And then a different group of plaintiffs sued, claiming that that was a racial gerrymander, which is a different doctrine under federal law. The state of Louisiana is defending its maps. And so the state is officially in support of the districts as they are currently drawn in compliance with the Voting Rights Act. But there is some thinking that the Supreme Court might significantly alter the standard that is used to assess whether or not a claim of vote dilution exists. It's very unclear at this point, and I don't want to get into too much speculation because with anything at the Supreme Court, there are many avenues that they could take. What we do know at this point is it's very likely that Justice Samuel Alito has the opinion in the court, and given his prior rulings on the Voting Rights Act, we have an idea of how he might rule, writing a majority opinion on a case like this. So even though this bill is mirroring federal law, just because federal law would change doesn't mean that the way it would be interpreted in Vermont would necessarily change immediately either. That's not the way court cases work. You would typically have some time with your law on the books as it is before you might have to consider a change of your own. Does that answer your question?
I think so. I mean, I'd
Okay.
love more, but it sounds like you're not willing to predict, but that, we know how.
You talking about prediction markets? No, that was yesterday.
I'll leave it
I
to
might-
the wisdom of Polymarket. Yeah.
Yeah.
Any other questions for Ben? No. If you want to stick around, feel free in case something pops up that you want to chime in on. If you got to go, we know where to find you, and you the same.
I do have to go. Thank you. I will be watching the live stream though. So if there's anything that comes up, I'm happy to respond.
Okay. Thank you so much, Ben.
Thank you. Take care. Bye, everybody.
And our next guest via Zoom, Helen. Hi, how are you? Helen Brewer, Senior Policy Specialist, Elections and Redistricting for NCSL. How are you?
Hello. Good. Thank you, Chair Byron. I hope you all are doing well as well. And it is good to see you again. I think we crossed paths at NCSL's election leaders meeting outside of Kansas City a few years ago, but it's been a while. So my name is Helen Brewer. I'm a Senior Policy Specialist at the National Conference of State Legislatures with the Elections and Redistricting Program. And I am here to give a lay of the land on state laws pertaining to the use of campaign funds for candidate security. I think also, I hope there will be time for any questions that you all might have. And I do have some slides that I will put up while I tick through this information, but please feel free also to chime in with questions at any point.
Will do.
I did want to take just a second for any of you who may not be as familiar with NCSL to give a summary of who we are and what we do. NCSL is a bipartisan organization. Every state legislator and legislative staffer in the country is a member of NCSL. And we produce nonpartisan policy research on a whole variety of policy topics, pretty much anything you can think of when it comes to policy topics. Another thing we are happy to be able to provide for you all is tailored training, research, and other services. And something we are glad to be able to say we can provide right now is resources from the NCSL Legislator Security Fund, which are funds we are able to allocate to legislatures for the security and protection of your institutions as well as yourselves as office holders. Vermont has already applied and been approved for the NCSL Legislator Security Fund. So if any of you are interested in more details on that, you can contact your sergeant at arms. On that note, I will also say that while I am here to talk about laws pertaining to candidate security, office holder security is also, of course, of the utmost importance to all of you and to all of us at NCSL as well. And our Center for Legislative Strengthening covers that topic here at NCSL. So I am always happy to refer you to them for information on the office holder side of things as opposed to campaigns. Lastly, I would be remiss not to mention our annual legislative summit, which is our biggest convening of state legislators, legislative staff, and other folks in the policy world. We host this every year, and this year it will take place in Chicago in late July. With that, I will move on to what I have to cover for you all today. So on the topic of the use of campaign funds for candidate security, I will start out with a quick overview of what laws are currently on the books in states around the country, as well as what pieces of legislation have been introduced this year. This will also be an overview of the different legislative approaches we tend to see to this topic in these bills. Then I will go over common types of expenses we typically see either authorized or limited. And then lastly, I hope to leave you with some details you might want to have in mind as you continue drafting and ultimately implementing possibly a law regarding candidate security spending, whether that is this year or, as Ben sort of mentioned in his testimony, if you're coming back to any pieces of this bill in future years. Starting out with general legislative approaches to the use of campaign funds for candidate security. A lot of the time, I think perhaps most commonly, we see this expense being authorized as an exception to a prohibition on the personal use of campaign funds. Many states have a law saying that campaign funds cannot be used for personal uses, and a common way to allow security expenses is to exempt them from prohibited personal uses, meaning that they are allowed. However, there are also states that affirmatively authorize campaign security expenses. This is more similar to the approach that you all are looking at in your bill right now. Another way that we see campaign security expenses authorized and fleshed out is sometimes in advisory opinions or regulations from state ethics commissions or campaign finance regulators, depending on who has that authority in your state. And then I will note that campaign expenditures on security services are typically, if not always, subject to the usual financial disclosure requirements that apply to all other campaign contributions and expenditures. So the current landscape around the country, there are 9 states that have laws pertaining to candidate security and campaign funds on the books. And there are, I should say, 2 of those laws, Alabama and Utah, were just enacted this year, and all the others are not too much older. 3 of them were enacted in 2025, and the others, I believe, still within the last few years. This year, in 2026, in addition to Vermont, we have seen 15 states introduce legislation on this topic. So this is a huge jump in interest in this topic, as you all can, probably imagine and understand. In 2025, 2024, and looking back from that in our databases, there would be maybe 2 to 5 bills or less or none on this topic. So before I move into some more details about what types of expenses are covered by these laws, I do want to point out that I'm going to cover only some specific examples. You can see there are 22 states that have engaged with this type of law in some way. And additionally, as I mentioned, some campaign security authorizations are fairly broad or general authorizations of expenses, like what you all have drafted in Vermont at the moment. So as I'm going through slides and saying, oh, 8 states allow this, 9 states allow this, it's not necessarily the case that those are the only states that allow those expenditures. They are just the states that specifically mentioned them. Just because a state law does not specifically mention a certain type of expense doesn't necessarily mean the law wouldn't be interpreted to cover that expense. That is really kind of the name of the game with these laws. So I did want to make that clear. So with that, who is typically covered by these laws and bills that we see pending or on the books in other states? Of course, all of these laws cover security services for the candidate themselves. A consideration if you're that you may want to have in mind is part of the question with candidate security is how far exactly does that extend? Does this apply to the candidate's home, to the campaign office? If the candidate has a day job, if you will, does it also apply to security services at that other office? If they run a small law firm or something like that. Almost all states also specifically mention that campaign funds can be used to cover security expenses for members of the candidate's family. And 10 states, either in legislation or laws that are on the books, specifically mention security services for staff. So turning from that to what type of expenses are covered. Again, I do just want to say one more time, there are some states with general authorizations that might encompass all or some of these. These are just the specific mentions that have been introduced or enacted so far. I will also pause here to say that the Federal Election Commission has issued regulations authorizing the spending of campaign funds for security services for federal candidates. So states are by no means out on a limb with this or anything. It's also an issue that has been at the attention of the federal government in the last few years. We have seen a lot of states, especially those introducing legislation this year, looking at specific types of security devices and monitoring services. As you can see, 14 states specifically authorize the use of campaign funds to purchase security hardware and for installation of that hardware. So this is something like some kind of an enhanced door lock or a security camera. Very similarly, 16 states specifically mention security monitoring systems being an acceptable use of campaign funds. This is something like a motion detector or an alarm system for a home or an office. And then 7 states specifically authorize some type of a cybersecurity expense. So this might be what you typically think of as cybersecurity software. A couple of states, Minnesota is one of them, also allows candidates to spend campaign funds on identity and credit monitoring services. And a couple of states have also started to look at authorizing expenses for services that find places on the internet where your personally identifiable information might be and that you don't want it to be, and remove it from there. And then lastly, and I believe of some particular interest to you all at the moment, there are 8 states that mention whether or not campaign funds can be used to purchase firearms. 7 states prohibit this use of campaign funds. They permit security expenses, but not firearms. You can see those states listed on the slide. Oklahoma's prohibition comes from an opinion from their ethics commission, not their statute, but I still wanted to include them here. And then Iowa has a bill, I should have written that more carefully. They have a bill that would permit firearm expenses. That's not an active law, though it says permits on the screen. All of this is a mix of legislation and statutes. But Iowa has a bill that would permit the spending of campaign funds on firearms and also firearms training.
That's
And with that, I mentioned I wanted to go through a few details that may be interesting or useful for you all to have in mind as you proceed. I do want to note that NCSL does not endorse any particular policy approach or another, just looking to give you the lay of the land and also a little bit of information about what we've sort of heard from regulators and campaign finance administrators and lawmakers as they have both written and implemented these laws on the ground. So one question that that some of these laws address, laws and bills, is when are security expenses necessary? This goes along with the language you all have drafted in Vermont authorizing campaign expenditures for necessary security services. What's going to be necessary? What's going to be approved? To determine this, California and Maryland had a bill, California is a law, would require law enforcement verification of the threat that the candidate says necessitates security for them. On the flip side, Rhode Island specifically says that law enforcement verification will not be required. A couple of the sort of thoughts that go along with both of these approaches: requiring law enforcement threat verification, as a couple of states would be looking to do, of course, provides a verified and closely tracked way that money that's already the subject of a lot of attention, campaign money, is being spent. On the other hand, an approach that doesn't involve law enforcement verification could allow a candidate to move quickly or move more flexibly or responsibly to some kind of a situation that arises suddenly. So a couple of thoughts on that front that we have heard. Another thing I want to touch on is some states have specific details about who candidates can procure services from. We see a few prohibitions on paying family members or some other close colleague for security services. And also there are a couple of states that require security personnel to be bona fide or registered with some certain security provider or agency in the state. There are 8 states that have or whose bills would implement limits on how much of campaign funds can be spent on security expenses. A couple of notes here. I will say Minnesota and California have current bills that would make some tweaks to their limits if passed, and California's cap, which is $10,000, would not go into effect until 2029. And then I did want to point out in Iowa, they do have limits on how much can be spent on candidate security, but they specify that any of a candidate's personal funds that they use on security will not count toward that limit. Lastly, the campaign is over. You have all won your seats in office. Now what? Now what about your security? There are several states that address what happens to funds or security services purchased with campaign funds once a successful candidate takes office. 8 states with either these laws or bills, their laws just already apply to both candidates and office holders, so that sort of takes care of itself in a clear way. And then, as you all may know, a lot of states have laws telling campaigns what to do with surplus funds and how to liquidate the rest of their assets once the campaign is over. So Alabama, Oregon, and Tennessee exempt security services that are purchased during the campaign from liquidation rules. And Tennessee additionally explicitly authorizes the use of surplus campaign funds for the office holder's security once they've won their election. And then California, Georgia, Maryland, and New Jersey do subject security services purchased during the campaign to their campaign liquidation laws. But for a successful candidate, that liquidation will not be required until the person leaves office. With that, I think the overall thing to note here is just states take a lot of different approaches and a lot of different levels of detail versus generality in their laws. Something we tend to hear from campaign finance and ethics administrators is that sometimes laws that are extremely specific and detailed in general, not necessarily on this topic, can make it a little bit hard for them to regulate and adjust to unanticipated or newly developing situations. But on the other hand, detailed laws, of course, provide lots of guidance to, in this case, candidates and also to regulators. And also, some of that would depend on how much you all want to ensure that you have the primary say in what campaign funds can and cannot be spent on when it comes to security. So with that, thank you so much for having me today, and I am happy to answer any questions.
Yeah, really appreciate all that information. So any questions for Helen at the table?
That's a lot of information.
Yeah, that was a lot of really useful input. I guess maybe one question I have in there, and this might be a better question for our elections division, but the difference, and I'm going into that firearm piece, but the candidate versus the official, I mean, you have to be a candidate at some point to become the official, perhaps, right? Or is there a differentiation there between appointed officials as well?
I do think probably your folks you have from your Secretary of State's office might know exactly how your statutes are worded. In general, the definition of elected official or office holder or whatever different states are saying in these statutes, this is not a satisfying answer, but does vary by state to state. So I also don't know off the top of my head how many of the states that address firearms address office holders and candidates. And then even within that, whether an office holder also includes an appointed office holder is also a state by state question. But I can at least follow up with you on which states do mention office holders or only candidates or both in the firearm legislation.
Okay, cool. I think that was the only curiosity nugget I had. Anything else? Before we shift over to last call for NCSL.
It answered every question I asked.
Yeah, no, that was actually,
Thank
that
you.
gave a lot of clarity to this conversation. So thank you so much.
Okay, I'm very glad to hear that. As
Yeah.
always, please be in touch with any questions you have, and I hope the rest of your hearing and session goes well.
Thank you so much. We really appreciate Jizzy Resource as well. So, okay, moving over. Mr. Sheehan, how are you, sir? Oh, yeah. That's awesome.
Oh, yeah.
Those baguettes, you can get a little slouchy on those things. Circulation gets a little iffy, you know.
Sean Sheehan, Elections Director, Secretary of State's Office. Thank you for inviting me to speak to this important legislation. I just want to make 4 points. First one will make addressing the issue of the firearms and the security issues. So I think first starting on that, just wanted to set the context, which we heard a little bit there as well. Just that Vermont's elections, local elections, state elections, federal elections, they're governed by local, state, and federal election law. And that includes the Federal Voting Rights Act and the important civil rights protection that's provided for more than 6 decades. As I think was discussed by the first testimony from Mr. Williams, there is broad expectation, anticipation that the country that the Supreme Court could strike down key sections of the Voting Rights Act this spring or summer. And as we've also discussed, and I think testimony also addressed that drum we've been beating, been the broken record of saying we don't change elections rules and procedures during election years. Seems to have gotten through. We've heard it repeated a lot. And that was really litmus test that we held to legislation here. We want Vermonters to be assured that existing election rules and procedures will remain as consistent as possible over the next 6.5 months. We want clerks and election officials to proceed with confidence and minimal surprises. And so we support this concept, the 8-page version, as was discussed, not the 24 or the 42-page version for that reason. We feel it'll help Vermont maintain as much stability as possible, regardless of what changes may come out of Washington. To those four topics, I believe will help with this bill, create greater clarity to existing rules and procedures. First was the questions around the safety protections. I think Ms. Brewer, that testimony was excellent. When we got the question about firearms, we went looking to see what other states did. NCSL had a terrific brief on the subject, but I think even all the late breaking news in other states that Ms. Brewer provided was very helpful. I learned a lot there. Here in Vermont, I think as Ms. Brewer discussed, there's some states that go into very great detail of what's prohibited, what's allowed. Vermont's statute, as legislative counsel, Mr. Devlin's spoken to much, has been much crafted to be more on the broader side, with the language being the quote necessary to allow a candidate to campaign, being kind of a litmus test for whether expenditures are allowed. And so in that sense, I think security expenditures that would be could be deemed necessary for a candidate to campaign would have been allowed in the past. They hadn't received much attention in the past. I was going to say in the past here, but from as we just heard, sounds like in the past all across the country. I think sadly, as our societies become more divisive, more threats to candidates and officials have increased, candidates are increasingly asking us about this topic as well. And so much as the case with dependent care a few years ago, which I think could have been seen as an acceptable expense if it was necessary to allow the candidate to campaign, but this body decided was beneficial to make that explicit, to call it out in statute. We feel it'd be helpful to explicitly call out security measures. To the question of whether security measures include the purchase of a firearm, I think both in looking at other states, as we heard, and from what I found had in my testimony when I saw Ms. Brewer say that Iowa allowed it, I was thinking I had to go back and edit my testimony before submitting the written, because we said we didn't know of any states that had it, and Ms. Brewer did qualify that Iowa hasn't passed that bill. So it is correct that no other states specifically allow firearms. However, of those states that do make specific allowances, expenditures on things such as home security hardware are some of the more common specific measures that are called out. And then to those states that make specific prohibitions, the ones that are in current law, as in the case of California, they do specifically exclude payments for a firearm. To that sense, I think, and staying broadly with our approach, I think, to this whole bill, now the Voter Protection Act, if it's renamed that, with S 298. To really not be making changes to rules and procedures. We think for this year, not swinging wildly from having our broad approach to getting specific with a lot of details. We think a simple one sentence addition to Section 4 of the bill, 17 VSA 29017, the definition where it currently is added, or for the provision of security for the candidate. If that was changed to, or for the provision of security measures for the candidate, security expenditures do not include firearms or other dangerous weapons. We feel that would be consistent with other measures and more in line with the level at which dependent care was called out explicitly. Second, we understand there's proposed amendments on remedies. We're supportive of those remedies. But we note that it's standard practice for courts to look to case law when resolving issues. We realize that with the Voting Rights Act being around for 6 decades, there's a long legacy. There's a robust trove of case law for the courts to draw upon if needed. The third area I wanted to touch on was personal data, including voter data, has been in the news a lot lately, from the federal level, and certainly concerns from Vermonters and privacy overall, and certainly making sure that there's also transparency in our elections. We feel that Chapter 43 of Title 17, which guides the Secretary of State's office and municipal clerks and how to safeguard this sensitive information, does well in the direction it provides to my team, the Elections Division at the Secretary of State's office, but is somewhat vague in the way it directs clerks. Specifically, that section, 17 VSA 2154, covers who can access which portion of the voter checklist and how they can access it. It's very clear that people that want the checklist from the Secretary of State's office, the statewide checklist, must go to the Secretary of State's office, and it requires the requester to swear or affirm that they'll use the data for legal purposes. And our office then uses an affidavit for that purpose, and the process works well. We've heard more questions from clerks because that same section 2154 forbids clerks from knowingly disclosing the checklist to prohibited uses, but not stipulating a process or an affidavit or an attestation for doing so. So we've received a lot of questions from clerks. We've told them that while statute doesn't require them to have requesters fill out an affidavit, there's no prohibition on them doing so. A lot of the questions we've gotten in the last year to that effect, we know some as clerks have adopted affidavits and kind of followed that process. But we've also heard from others that appreciate consistency and clear directive in statute. We have a simple change I can provide, saying a couple sentences to 17 VSA 2154C, which would provide clerks and Vermonters with that consistency by mirroring the language that Secretary of State's office follows when there's a public records request for a checklist, and mirroring that for clerks as well. The fourth area to flag, I know there's been some question about the effective date. Our office supports the bill being effective on passage. That was one of the big reasons we supported the bill, the prior version of the bill, being narrowed down from that much longer bill that was introduced, because we want that election year bill to focus on codifying current rules and procedures into state law. We felt that if there were pieces of the federal law that it could be codified in state law, there's no reason they can't be effective on passage. And if there's pieces of the bill that don't impact Vermont or would be more ambitious than what's in federal law, we feel that those should be subject to a more robust discussion, which typically takes place in odd numbered years. And so as such, we feel this current bill hits that mark, and we feel a sensible approach would be to make it effective on passage to provide stability for this year's elections.
Anybody have any questions, Rep. Pincinel?
Do you have any objections to having a limit it's put in here as to what that can be spent on? The expenditures for the campaign security?
We don't have specific objections to it. I think our support for the reason of being the one simple sentence would just be, as I mentioned, staying consistent with the way our campaign finance law focuses heavily on the disclosures, on the filing of the reports, and the broad tie-in to that, the language of being necessary to allow a candidate to campaign. Again, I think that would certainly be open to that conversation with all of you and to the legislative council, but and advocates. But we think in general, if we were to be getting more into the details of limits that can be spent on certain subcategories and other details like that, we feel that would be a bigger change, more appropriate for a different year, but we aren't categorically opposed to it.
Question came up earlier about an appointed versus an elected official. Do you have any opinion on that?
I think with the campaign finance in Vermont law, really focus the candidate being on the campaign, from the time that they announce and that there's three triggers in statute for when they become a candidate. And that's in the campaign finance section. So this portion of really being the campaign finance part on being the candidate, we see that being the definition on there for the expense. Now having said that, I think putting the language in, if somebody's allowed to make these purchases, and I think part of the way it's generally been determined is, as Ms. Brewer said as well, kind of when there's that personal benefit or that need beyond. We've read both other statute and other states kind of talk about a nexus to the campaign. So I think if that purchase is made for the campaign and somebody buys cameras for their home and so forth and continue to use them when they're an office holder, we don't see that as something that would be prohibited in that sense.
Brett Pinstall.
I'm gonna go back to the expenditures again, sorry. If we were to make an amendment to that, would we do it at this time or would we do it after we? I mean, I just wanna, I like what the NCSL had, where it was specified that a dollar amount maximum, that it can't be used for guns, that it has to be used, if it's used for a limitation on how much you can spend on home cameras, that kind of stuff. I just think this right now is just too open-ended. If we're gonna pass a bill, let's pass it with.
Let's hone it in and make it.
Yeah, right. So is that for committee discussion time rather than when we have a witness
Yes.
in front of us?
Yes, I think that's no, but I think we're all agreeable
Yeah.
that we need to hone in that
We have to
language,
hone in
make
that
it more
language,
focused.
yeah.
Yes, absolutely.
Did you have a question?
I don't know, maybe. I kind of want a history of this section, like what?
So which section again? Are you
Okay,
on?
numero.
The security section?
Security, yeah, I'm like, is this really?
If you look back at all the drafts the Senate GovOps had, there's a lot.
The thing about it is like, to me, this adds to the issue of security in politics, like to emphasize. I don't think Vermont candidates are in grave danger.
I think my wife would beg to differ.
That's fair.
I can play you some voicemails.
I'm sure you can't, but
I was just gonna say, as a single mother lives in the country.
well, listen, I'm not gonna say like, okay, all you guys with your concerns, those aren't legitimate. I'm just like, I don't see it the way others do. I don't see that stuff as much.
It's not so
I'm
much.
very happy for you that you don't have that.
Maybe he's gonna
It's
do a
not
good job.
discussion.
Oh,
So yes, we'll do this after our witnesses. Yeah.
oh yes. Well, okay, the question for the witness, if you don't mind, John. Implications of the Louisiana case. Do you have thoughts on that for us? I mean, your fourth, the flag, right, was the effective date. My understanding is you want us to not quite do this right now, but wait. Is that true?
No, I think, my recommendation was that it'd be effective on passage.
Okay.
Yeah, for that reason. Yeah, and that I think is why we were supportive of this bill coming at all during this year is because we felt this bill would provide greater assurance, greater stability in the case of potential risks coming out of Washington. If we didn't feel those risks were there, or if we thought things could wait till next year, we would have preferred for this whole debate to be happening next year and for a whole bill to be starting up. So really, that was why, with a lot of measures and pieces in the, I think some of the iterations on the Senate side talked about effective dates for next year for some components. Our thought on those was that if they can wait until next year, or if they're going to be adding new levels or more, be more ambitious, be more, seek improvements in how we do our elections, we certainly recognize and agree that we can make improvements across the board, but we feel those improvements are made during odd numbered years, not in the run up to an election. So with, I think with the Supreme Court and Calais, I don't have a better, probably have less of a prognostication. Yeah. What will happen then, the folks monitoring, you see at the daily level, but my understanding is Supreme Court does tend to come out with, that they are likely to come out with a ruling. They tend to come out with their rulings in the early summer period. And if they do, there's a good chance, as we heard, that significant parts of the Voting Rights Act could be gutted. If they are gutted, that would mean changes in the weeks before our statewide primary in August, months before November. Whether or not that changes things, whether or not there's time or they wouldn't go into effect right off, there would be that sense of uncertainty on the part of clerks, on the part of voters. So having a bill that can codify what's in federal law into state law would be telling Vermont clerks, telling Vermont voters that we're seeking.
Okay, I got Hango, coughing, Waters,
I swear I'm
Evans.
missing. My question makes it seem like I didn't miss.
Well, mine might as well. So, that all being said, I understand about the potential rollback of the Federal Voting Rights Act. Section 4 that specifically deals with safety protections for candidates. My understanding is this is like kind of an above and beyond provision. It's not in the Federal Voting Rights Act.
Yeah, that's correct. Yeah, and it's not, but again, we don't see this as a change per se. I think much as the law a few years ago around dependent care was made explicit, we feel this would be making security measures explicit. We feel the candidates in our read really that if candidates tie their expenditures to what is quote unquote necessary to allow a candidate to campaign, that would be allowable. Having said that, knowing that this is getting a lot more attention, that's something that we hadn't gotten a lot of questions about in the past. We always prefer, and we certainly consult with the Attorney General's office when we get new questions for our read and interpretation, but because some of the details really intent come out of the legislature, the more often the legislature can make language explicit, we feel that's better for candidates, better all the way around, to not for us not to be having to making interpretations.
Thank you. And do you remember the dependents of candidates, that portion of the law clarifying that allowable expense? Do you remember what year that was done in?
I don't write off. I believe it was in the last decade.
It wasn't very long ago.
No.
As I remember it, I was just wondering if it was in an election year or not, because I'm feeling like we're gonna have to be, we're already filing campaign finance reports for the 2026 general election. So if this were to take effect on passage, I think it would take a little bit of education, bring people up to speed in an election year on what they could and could not be doing for their own personal security. So for that reason, I'm a little hesitant to have it included in this bill right now, but definitely open to conversation, and I will yield to the next person to speak.
Coffin, Waters, Evans, Nugent.
So with Louisiana v. Calais, whichever way they say it, what parts specifically, because you're the second witness to say it could significantly affect, what could it dismantle in the Voting Rights Act? I don't know enough about the case.
Yeah.
So besides the race-based districting that they were talking about, what else could it tear apart based on the argument?
Yeah, I think, and that's an area, I think also, the witnesses you had this morning from the Attorney General's office may have been more expert on that area to speak than me. But my understanding is that the whole voter dilution piece would be a significant component, but it could potentially be, much broader of the entire sections around there, which, there's pieces, and as we discussed, a lot of the pieces that have to do with voter assistance. There's sections in the Voting Rights Act relating to people who are elderly or have a disability to get assistance at the polls. That was a piece that was in the bill before. That was a piece that we talked about made more sense to come out because Vermont law was already stronger in that capacity that any voter can have it. But those sections around that, around vote dilution, voter assistance, around the language assistance, which also had been discussed in here, with Vermont being at a threshold with our towns being smaller, as we discussed, wouldn't be impacted as well. So really, and I think a lot of the the remedies and potentially the piece around the threats and coercion were parts that are in the section that I understand are being looked at by the Supreme Court. So really, what's left of in these 8 pages, I think, are the pieces that were in the Voting Rights Act that could be codified into Vermont statute, not making changes for Vermont, but giving that additional security and stability.
Okay, no, yeah, I was just really curious, which I don't know enough about. And now we have a lot more reading to do, but because a lot of it was based around the race-based redistricting. And that's why I wanted to know what else is going to be affected. Instead of just saying it could dismantle everything.
Right.
It could dismantle, because that sounds like fear mongering. That if we could get it on record, the specifics of what they're looking at.
Yeah, absolutely. Yeah, so the pieces beyond, and that's a good point too, for the sides of a lot that has to do with the redistricting and coming out of, I think, the initial drive for it certainly was in the Jim Crow South and districting at that level. But a lot of the protections in the Voting Rights Act for redistricting, would apply everywhere as well. But they're pieces because Vermont, because we're not like a bunch of states doing redistricting mid decennial census as well. That was a piece that we felt, even if that part changed, didn't need to be in this version of the Voter Protection Act, because we'll have until 2031, 2032 to really be crossing the bridge of redistricting. And so that would give ample time in next year or even the next few years to work in protections if we wanted to mirror those portions of the Voter Rights Act into Vermont law. But the portions that were here were really much more around that voter assistance, voter dilution, having that the remedy and the private right of action.
Thank you.
Brad Waters Evans.
I feel like my question might have been answered already, but just to clarify, if we pass this bill, then it is a seamless, maybe not seamless, but fairly seamless transition, were the federal Voting Rights Act to be dismantled. It would just kind of keep everything moving. There would be no extra new work on your part, right?
Correct. I think on our part, on the part of, I think, of particularly the rules and procedures of, I think on our office, on clerks, on voters and people that influence, there'd be no requirements, shifts. What's allowed would still be allowed, what wouldn't be, still wouldn't be. I think as the Attorney General's office spoke to, I think some of the shift that would potentially happen if there was a change at the federal level and the remedies being sought through instead of being sought through the federal system, being sought through the state level. And so I think the language that as well provided this morning about that, I think really spoke to their investigative piece. So I think the piece that would potentially have that change would be to the General's office for how those complaints are investigated and pursued. But as far as what's allowed, what's not allowed, and the protections that are in place for clerks, for voters, for others, those would be consistent.
Okay, and my other, thank you. Ironic that passing a law about elections in election year will keep elections. Who would have thought? And then the other, I mean, do you think it's fair to say, and this is just maybe me secretly just giving my opinion, but asking if you agree, is I feel like when the, you know, I know that we've said maybe your office said we should call it voter protection as opposed to voting rights, because it's kind of a whole different thing. But also, it seems to me like the security part is more of a campaign finance issue and not really like a voting or voter issue. So is there a generally accepted policy about campaign finance changes in election year? Is it something that would cause any extra work for your office, or would it just be a new thing added on to things that already exist?
Yeah, we think it would just be really providing that clarity. I think to the question, as Representative Hango said, for getting the word out. Certainly, we're taking these questions as it is right now. The way we're answering them right now is it's not specifically called out, but we're pointing to the expenses that are necessary to allow a candidate to campaign. Go ahead and report those, disclose those in the campaign finance filings. So I think to the extent that there was a passage of a bill, as in this case, that made it explicit, we would be able to get the word out and those responses we give individually, but also in communications to the parties, as well as in our office hours and FAQs and so forth. Of this has been explicitly called out in this bill and now is in statute. So it wouldn't be changing the answer that's given in the sense of guidance or anything. It would be, but it would be making it explicit that statute says this, as opposed to an interpretation based on that necessary to allow a candidate to campaign language.
Thank you.
Eugen.
I think, yeah, my question's been answered somewhat, but I was wondering about how the Voting Rights Act applies to Vermont specifically. And I guess I'm not fully clear on, because part of it applies to just certain states that have been found to be doing these things that they weren't supposed to do, and and that enables the federal government to preview new election laws before they're implemented. Are they allowed to do that, or do they do that with any other states, or can they? Or I'm not sure. Yeah, how that applies.
Yeah, that one I have to, I think, come back on a lot of the council. I mean, I know I can say broadly, a lot of the laws, the requirements is the cases of assistance and pieces like that. Certainly, parts of the processes that are in place when it comes to redistricting, the other measures, all those pieces. I mean, they're in federal law. They apply to those apply to all states. I think when you get into some of the investigations, maybe at the federal level on certain pieces, I think as you talked about, I don't know if it's necessarily they're not applying, but where those interventions has been when there's been a case brought, or as I think was mentioned with NAACP, for example, bringing case through that private right to action, if that was looking at a particular state and particular processes. There's certainly some requirements that apply to larger jurisdictions, don't apply in Vermont because we don't have any big cities, other things as well. But I think for specific, if you had other questions on that, we certainly could try to get another witness or gather more information. Happy to follow up.
I see a hand up.
Yeah, you did. I'm trying to find it on the campaign website, the campaign finance website, but I probably am not looking in the right place. There's a drop down menu when you go to fill in your campaign finance report, and it's very specific about what you're using your money for. So you'd have to alter that somewhat if we added in certain things to this bill that are allowable. Is that correct to assume?
To add a drop down, I'd have to go back and review that to see if it would be something we would have, give the guidance for others that fall into existing category, or whether we would add a drop down. I think it could be done either way, but we would certainly do whatever we felt would be clearest for Kim.
Anything else for the elections director? Well, we got him. Oh. All right, I think this was a good block of time today. It's helping us hone this in. I'm feeling less meandering. All right, thank you very much, sir. This is not the end of the conversation on this bill. All right, good work, committee. We'll start refining this. We're gonna have Rep. Goodnow come in tomorrow and talk to us about that language with H 541 that was suggested we include. So he is the reporter of the bill and the primary shepherd of that vehicle. So he's gonna give us a run through. And then we're gonna dial in some more testimony. Hopefully, I think I want to focus on this bill with our gaps on Friday. And maybe even sprinkle in some like merchant and other testimony in and around the Stone Charter. So that's what I'm thinking for the wrap on the week. With that,